Your
Okay, let me get the workbook open.
already.
Alrighty, I'm on the first page, I believe.
Okay. Okay, good. So, have you been?
Doing all right.
Any of your job prospects panning out?
I have not heard from them, so I've just been job searching other places. Tomorrow there is a cybersecurity job fair, and I believe that's from 5 p.m. to 8 p.m. So, you know,
That's wonderful.
hopefully, go from
Right.
there. I graduated top of my class.
Oh, well, good. That's exciting.
Mm-hmm.
So they'd be lucky to find you. You know that?
Yeah, it's kind of a jealous industry, but I just got to get my foot through the door.
Sorry, there's a little bit of noise here.
What's up?
I have a little bit of noise going on. It'll be over in a minute.
Okay. Excuse me.
Oh my. I had a sneeze attack yesterday. Okay.
Oh.
You okay?
Yep.
All right. So I have 7 questions I need to ask you. Hold on just a second.
Okay.
Okay, that should do it. All right. So do you receive any peer support services?
Not to my knowledge, I have no idea what that is. What is a peer support services?
Like a mentor or something like that?
No.
Okay. Do you have any medication management services?
I'm not on any medication.
Okay, so you don't. Are you on any substance abuse services?
No. I quit smoking marijuana and basically quit drinking alcohol for the new year.
Wonderful. Do you have any case management services?
None.
Any mental health services?
None.
Okay, so I don't know what this is, but if you know, it's an acronym. It said ACT, ACT services. I'm going to find out what that is, but I don't know.
ACT services. I will look. ACT services. Assertive community treatment. Is that what you're asking about?
I think so. I have to verify it. These are just 7 questions they asked me to ask you. Do you have any of that?
Nope.
But you know, okay. And then there's one more acronym that I have to verify as well. This is a new thing. IDD services.
IDD.
He is a doc. So
individuals with intellectual development disabilities. No.
I believe that's what it is. None. Okay. So no, none of the above services.
None.
Do you have any in any of them?
Say that again?
Do you have any interest in any of them? Because if you do, then it's my job. That's a new thing for my job is that I have to try to find them for you.
Every time I go through, I talk to any of my, I have a pretrial service officer, and I'm only looking for a cybersecurity IT job, and she recommends Indeed. So I just go to these cybersecurity events and do what I can.
Okay, so you just need employment help.
That's the plan.
Yeah. Okay. I'm glad you have what did you call that person?
Pretrial services officer.
Yeah. Yeah. Very good. Okay. Okay. All right. My daughter does that job. One of my daughters in Jefferson County. She likes it pretty well. Anyway, yeah. What county are you in? Denver?
I'm in Denver County.
I think they have at the Human Services Building a workforce program that maybe they could help you. I don't know.
That's how I got in the class.
Okay, so you were familiar with that. Good. All right. All right. So in our curriculum, we'll just go over it. We have 16 modules, as you probably noticed. And you've taken this before, right?
Yes, ma'am. Each module took a half hour, or we reviewed each module for a half hour for a couple weeks straight.
Yeah, and did they retest you or that? I don't know. The thing of it is that I never know when they're going to retest you. I would hope quickly, right? Because you probably know most of this stuff. I'm sorry for the repetitiveness of it in advance. So, how do you like to learn? Do you want me to read things to you or introduction to see if you know it? How would I best not annoy you?
Well, last time I did this, we went along together. Sometimes the other lady would read or I would read, and she would ask me, what does module 1 say? And I would say, Introduction to Competency Restoration, Understanding Why I'm Here.
That's exactly right. And do you know why you're having to take the class?
I was found incompetent to proceed.
That's right. So you already know that terminology. And that doesn't mean you're incompetent as a person. It means that the judge or evaluated you felt like you needed more support with regards to the goings on in the courtroom. So, because obviously you're not incompetent, right?
I believe I'm competent.
It's a court order.
Yes, it is a court order. I understand that.
Okay. And already told me that the first vocabulary word, which is ITP, and do you know their meaning of restoration? That vocabulary word, the definition of that.
What are you asking me? Are you asking me the definition of ITP or restoration or competency?
Good point. I'm asking the definition of restoration and within the scope of competency restoration.
The act of bringing back something that existed before. Restoration can be used with this program to describe an individual's process to competent to proceed. So basically, I can communicate properly with my public defender, and my public defender can commit due diligence and facilitate a proper defense.
Couldn't have said it better myself, Kenneth. Thank you. And do you have a good understanding of the word competency as far as our vocabulary is concerned?
The definition is your skill or ability in a specific subject matter or being able to do something well or to understand how to assist in your own defense during a trial. I believe I'm competent. There's been a couple of times that the court-appointed attorney basically said that they're not going to do much. That if I wanted certain things done, I could get a real lawyer or I could do it myself.
Mm-hmm.
He's even said that in front of the judge.
That's pretty, okay, that means plea and obviance then, because that means that you can defend yourself. Okay, so skill, a talent or ability that comes from training or practice, and you will use many skills in this course and learn new skills to help you. And then, of course, priority, something given special attention, making something a priority means that is important. And I think this course is important in the sense of it doesn't hurt to review, right? And then you're being compliant with the court. Would you?
I believe that I can do it. I've done these classes before.
Yeah.
This isn't the first time this lawyer has requested a competency eval.
I'm sorry.
It happens.
So here's a pretest, and you're gonna nail this. I just know it. So number 1 says, I have to complete this course because the court ordered competency restoration education. True or false?
That's completely true.
That's right. And what does incompetent to proceed mean?
Incompetent to proceed basically means that I do not competently understand the legal process nor the legal proceedings, nor can I properly facilitate my own defense, nor can I properly help my lawyer with a proper defense strategy.
Correct. Number 4, you can go to trial on your charges, and then there's a blank. A, whenever I want. B, never. C, when a doctor finds me competent. And D,
All right, you cut out right there. So I'm going to go ahead and say D. Hold on, let me check my audio. 1 second. Are you there?
I'm here. Can you hear me, Dennis?
Yeah, let me redo this real quick. All right, can you hear me?
I can.
Awesome, because I can hear you. Okay, well, I will go with the answer D, when the judge finds me competent, because the judge has to rule I am competent to proceed, and he finds that based upon an evaluator's documentation.
Mm-hmm. You're correct. Well, we just reviewed module number 1. Module number 2 is criminal constitutional rights of the defendant. And you know, of course, that you're the defendant. So here's a pretest. It says the defendant's right to remain silent is the following right. Is it the 5th Amendment, the 6th Amendment, or the 1st Amendment?
I believe it's the 5th Amendment that protects against self-incrimination.
That's right. And the right to a speedy trial is the 5th or 8th or 6th Amendment.
I'm not sure. I think it's the 6th. I can look it up.
You're right.
Oh, okay.
No need. You got it. And the requirement that government officials must follow fair procedures before depriving a person of life, liberty, or property is A, the right to sit wherever you want to in court, B, due process of law, or C, both A and B.
The requirement that government officials must follow fair procedure before depriving a person of life, liberty, or property is B, due process of law.
Very good. Yes. You can be tried for the same crime only once, 3 times, or as many times as the judge wants.
Technically, it's A, but I've actually gone through a federal trial that was vacated. I went through an appeal and it was vacated, which means that they were allowed to try me again.
Gee whiz, sorry.
It happens.
But typically you're right, only once.
Only once.
My goodness. Okay, number 5. The rule that prevents evidence gathered illegally from being used at a trial is called A, no good evidence rule, B, exclusionary rule, or C, the judge's rule.
I believe it is B, the exclusionary rule.
And you are correct. Do you realize you're 100% on this, all this already? Okay.
Well, I went through this before, and prior, we only did one module per, what do you call that, meeting.
Oh. But there's not enough information for one, wait a minute. What I'm trying to say is that we have more time, don't you? Really, how does that happen? Because how could we speak about module 1 for longer than 15 minutes, really?
Yeah, they were only a half hour long. And so we would discuss, would go through the, what is that called? The vocabulary. We would discuss each vocabulary term. And then we would go through the entire module. And then we'd get to the test.
Okay. Oh, maybe, how long's that been? How long ago were you taking?
That was last year, and the what do you call that? Like I said, they were a half hour tops, and if we ended early, we ended early, and they lasted roughly, I think it was 16 weeks, 1 week per module.
Okay, and so we're supposed to do 2 hours a week. We've opted to do once a week, which really is an hour and a half because they allow me 15 minutes per session to put your notes together, you know, of what we covered. So an hour and a half is what we have. And we are 17 minutes in.
Yeah, where does the hour and a half, is that mandated by law?
Well, that's the directive I get from the state. Okay, so what they're telling me is that you need to meet with me 2 hours per week. And out of those 2 hours, it could be 1 hour each time or a total of 2 hours. But they allow me 15 minutes per hour to do your notes because I have to say what we covered, right? And so it ends up being for you an hour and a half. You get it?
Okay. All right.
Yeah. Does that make sense?
If that's what the state mandates.
Yeah, that's what they told me. Let's see. Okay, so now.
Question 6, true or false?
Yeah,
I am presumed innocent until proven guilty. That is true.
That's right. You can go on if you like.
Question 7, true or false? The Miranda warning begins, you have the right to remain alive. That's not how the Miranda goes. It's you have the right to remain silent, so it's false.
That's right. But I would hope you have the right to remain alive, but it's not the Miranda.
And okay, I believe the Supreme Court has ruled that Miranda rights are irrelevant and they no longer have to be read.
Wow, I didn't know that. Okay, how about 8?
True or false, you have the right to an attorney at any point in the legal process. That is technically true.
And number 9?
You have the right to confront and cross-examine all witnesses against you. Yes, again, true.
Okay, so I have like the teacher's manual, and I don't know if you have this information in your book, but do you have more extensive explanation of the amendments, like the 4th Amendment, the 5th Amendment, the 6th, the 8th?
In mine, it's page 10. It says activity, review of vocabulary and terms below. Starts with the Fourth Amendment, then it highlights warrant, then it also highlights search and seizure. And then there's Fifth Amendment, and then it goes to self-incrimination, due process of law, Miranda warning. Then the Sixth Amendment, and then the Eighth Amendment.
Yeah. I'm going to bring up your version too so that I can look at both. I have a hard copy of the basically the teacher's manual, and then I'm going to look at yours. You don't have to apologize. I have to apologize because I typically work with children, which is a little bit different than your curriculum.
Oh.
So I'm kind of new to the adult curriculum.
So is it, are we going off the children's guidelines for an hour and a half, or is that the adult guideline?
Well, I'm going over the adult guidelines with you because it's more extensive. So, like, I've memorized the children's, but I haven't memorized the adult yet. So, I'm bringing up your manual now. No, I wouldn't. That wouldn't be appropriate. You need more information than we give a child, you know. So, do you have any questions on the Fourth, Fifth, or Sixth Amendment, the Eighth Amendment? Would you like me to read this to you, or are you good?
I'm good.
Okay. And basically, at the end of my workbook, they're just giving you that assessment that we just did, which you got 100%. So I don't see any point of reviewing it unless you want to.
It's the same questions over, right?
Same questions over.
All right, so then to module 3.
Yep. Which is understanding roles in the courtroom, what people do and where people sit. So the objectives of module 3 are to identify the participants in the courtroom, identify where people may sit in the courtroom, and understand the roles of each person in the courtroom. Okay?
Okay.
So now you have a whole list of vocabulary. How would you be most comfortable addressing that? You want to read one and I read one, or what do you want to do?
I can read them if you'd like.
Oh, that would be nice. You know, you have such an amazing voice.
Thank you.
I don't like my voice very much, but I really like yours. I mean, you could be on the radio.
I will take that as a compliment.
Absolutely. Okay, sir, go ahead.
Lawyer, another name for an attorney. Attorney-client privilege, a rule that preserves the confidentiality of communications between lawyers and clients. The purpose of the privilege is to encourage clients to openly share information with their lawyers and to let lawyers provide effective representation. Pro se. This means advocating on one's own behalf before a court rather than being represented by a lawyer. Defendants are automatically assigned a public defender if competency is raised, and the option to go pro se can be revisited once restored. Defense attorney, public defender. This is an attorney that works with you and helps with your defense. The defense attorney is the only person with whom you have attorney-client privilege. Prosecutor.
Do you know what that, excuse me, do you know what attorney-client privilege is?
It basically means anything that my lawyer and I discuss cannot be discussed outside my lawyer and I unless it is something I mention that is either harm to myself, harm or others, or a possible future crime.
Oh my goodness, I question why you're taking this class. That is an excellent response. Okay, well done.
Prosecutor, district attorney. Lawyers who investigate, charge, or prosecute people whom they think have committed a crime. Judge. A person who is in charge of a court of law and who makes final decisions in legal disagreements. Judges are impartial decision makers in the pursuit of justice. Defendant. A person who has been accused of a crime and a claim or charge is brought in a court. Witness. A person who may know something about what you did or didn't do. A witness will testify from the witness stand. answering questions asked by both lawyers meaning the prosecutor and the public defender.
Mm-hmm.
Bailiff, an employee of the court that enforces the judge's orders and announces events. Clerk, an officer of the court whose responsibilities include maintaining records of the court and to administer oaths to witnesses and jurors. Court reporter, a person who makes a word-for-word record of everything that is said in court. Jury, a group of people who attend a trial, listening to the testimony and evidence and make a decision, render a verdict if you are guilty or not guilty of the crime to which you have been accused. Trial, an occasion when the court, with or without a jury, decides on your guilt or innocence or decides on the penalty. Hearing, a court hearing is a gathering within a courtroom for the purpose of conducting a legal procedure, such as a motions hearing. Verdict. In a court of law, the verdict is a decision that is given by the jury or judge at the end of trial. Guilty verdict. The judge or jury decides that you have done and are responsible for the crime to which you have been accused. Not guilty verdict. The judge decides that you have not done and are not responsible for the crime to which you have been accused. Well, the jury can also say not guilty, not just the judge.
That's right.
So it seems like there's a typo right there.
Might be. How I understood though, that the judge has the final say, but I think I'll check into that.
I always thought that in a jury trial, if the jury finds you not guilty, you're supposed to be not guilty. But I understand completely that if the judge wants to rule you guilty, the jury trial is irrelevant.
That's what I was thinking.
I don't understand how that's possible.
I know. Let me look into that and see if I can get you an explanation.
Okay.
So then we are on page, let's see. I should ask you, do you have any questions or concerns? Do you understand all of the vocabulary you recited?
All the way to the not guilty verdict. I always thought that if a jury rules you not guilty, you're not guilty.
Yeah. Let me verify that because I don't want to give you the wrong information, okay? But well done. So, and there's that diagram, I mean a space bar diagram of the courtroom. Can you kind of tell me, I know this is hard virtually, like where everyone sits? If the top of the page is the front of the courtroom. Basically, like that's where the judge sits, and then in front of the judge is what?
Okay, identifying individuals in the courtroom. Use the space below to draw a diagram of who's in the courtroom and where in the courtroom they find them, including the judge, the defendant, the defense attorney, the prosecutor, the jury, and the witness stand.
Yeah. So basically, the judge's bench would be at the top of the page, and then the defendant's table and the plaintiff's table would be in front of the judge's bench on either side, right? Typically, and the prosecutor would sit at the plaintiff's table, and then the defense attorney would sit at the defendant's table, and then the jury they're showing it over to the right where there'd be the jury box, and then to the left of the judge is what my diagram shows is the witness stand, and to the right of the judge is the court reporter's table, and in front of the judge they have a court clerk's table, and the court clerk is the one that helps organize the judge and also presents the oaths to the witnesses when they have to hold your right hand up and say, I solemnly swear to tell the truth. Does that make sense? Have you discussed that before?
Yeah. If I was sitting in the right of the courtroom, next to me would be the defense attorney. Behind
Mm-hmm.
me would be the gallery where people can witness the trial. To the
Right.
left, the table left to where I would sit is the prosecutor. That's where the prosecuting attorney and witnesses for the prosecutor would be sitting. Directly in the center, across from me, would be the judge.
Yes.
On either side of the judge can be the court clerk and the court reporter who records everything. Can be anywhere. It could be in front of the judge or it could be on the side of the judge. But normally they're in front of
Mm-hmm.
the judge.
That's what I thought too. And my diagram shows it to the right of the judge. But I think you're right. I've seen them in the middle of the courtroom because I think that's where they can hear better. But yeah, you're right. So we can go on to the questions. And number 1 says, what does the judge do during the trial?
The judge is supposed to also protect my rights, make sure that no lawyers are committing any unethical, immoral, or illegal activity, and rule on motions and objections.
Right, the admissibility of evidence. You're correct. And I teach that the judge should be neutral. They shouldn't take sides.
Yeah, the judge
But
is
the court,
supposed to be a neutral third party.
that's right. And the court system is a two-sided system, meaning it's your side and then the prosecuting side. And the judge is supposed to be neutral. Okay, so what does the district attorney or prosecutor do?
You skipped what does the jury do?
Oh, excuse me, I did. I sure did. What does the jury do?
The jury listens to evidence and witnesses and testimony, and then makes a decision based upon that on whether they are guilty or not guilty. I looked it up
That's
online right here where it says, can a jury find someone not guilty? And says yes. Acquittal. Judgment that a criminal defendant has not been proved guilty beyond a reasonable doubt. In other words, a verdict of not guilty.
mm-hmm. Right, because they didn't feel like there was enough evidence, correct?
If that's their determination.
Yeah. Well, thank you for that. That's a great answer to number 2. Now, what about number 3? You want to read that? What does the district?
What does the district attorney or prosecutor do? They present evidence that will facilitate a guilty verdict.
Yep. And number 4, what do witnesses do?
They testify to what they witnessed.
Right. And we have 2. I try to teach that we have a couple of types of witness. That's an eyewitness and a character witness. Do you know the difference?
An eyewitness was somebody who was there and witnessed the alleged activity or witnessed activity that was not alleged. A character witness testifies as to the character of the defendant.
Correct. The defense attorney or public defender works with you to show the charges against you are not true. Is that true or false?
The defense attorney or public defender works with you to show the charges against you are not true. I believe that's true. The public defender works with you to show the charges against you are not true.
Mm-hmm. Okay, that's right. I bet you could. I just don't understand why you're taking this course, because you seem to have such a grip on the information. But it is what it is, huh?
Well, I keep requiring my lawyer to do due diligence, and he keeps sitting there and calling me incompetent. So basically, he's
You're
just constantly calling me incompetent so he doesn't have to do his job. That's how I feel about it.
Aw. Oh, I'm sorry. But you're doing very well. I just feel like you really understand this, but who am I to say, right? Um, but we have 16 modules, and maybe there'll be something I can help you with, you know? You never know. So can you please tell me what module 4 title is?
Module 4, relating to your attorney. This module will introduce you to the importance of collaborating with your attorney and assisting in your defense. The module includes identification of one's legal rights associated with the right to an attorney and confidentiality, identification of important information to share with and ask an attorney, as well as problem-solving strategies related to collaboration. The objectives of Module 4. Objective of this module is to introduce the importance of working with one's attorney to assist in their legal defense, familiarize them with interpersonal problem-solving strategies, and orient them to what information is important to share with their legal counsel. Explore who is my attorney and what is their job. Discuss any perceptions or feelings associated with their attorney, specifically regarding the attorney's ability to help them. Identify important information to share with their attorney related to their past and current allegations.
They're very good.
Would you like me to read the vocabulary?
Yes, if you wouldn't mind. Am I tiring you out?
What do you mean, am I tiring me
Are you doing
out?
okay? I mean, your voice. Are you okay?
I guess.
Okay. All right. I would just love to hear you read.
Vocabulary: collaborate, work together to create something, a legal strategy, such as collaborating with your lawyer to facilitate a proper legal defense.
Right.
Confidentiality.
Yep.
What's that?
Partnering.
Yeah, partnering.
Mm-hmm.
Confidentiality. Keeping information secret, not allowed to repeat the information you shared. So if I tell my lawyer something, he has to keep it secret, unless it's harm of myself, harm of another, or possible crime to be committed.
What if you told me something, but please don't, because I don't want to know any of those things about your case. Would I be obligated to keep your confidentiality?
I think to a certain extent, but again, if it's harm on myself, harm on another, or a possible criminal activity, I believe by law you have to repeat or you report to the legal authorities.
I do that, and I have no one besides your defense attorney has an obligation to keep your information confidential. So you have to be careful. I try to teach my students, be careful who you tell your story to, probably be best just to avoid it, because you'd be risking somebody being subpoenaed that might hurt your defense, you know? So the only one that can give you the client attorney privilege or the confidentiality that I would hope you would want would be your defense attorney. Is that new to you?
Nope.
Okay. I just don't want you to put yourself out there and then have the court subpoena somebody and then you told them something in confidence and then they had to be under by law have to repeat what you said, you know? Okay. How about verdict?
What about client attorney privilege?
Yeah, let's do that. I keep skipping ahead, don't I? Sorry.
Client attorney privilege. This means that information you talk to your attorney about is confidential. This gives you the ability to be completely honest with your attorney about all details of your case.
Okay.
Verdict. A finding or answer of a jury given to the court concerning a matter submitted to their judgment. And when I was looking up online, I've looked up, can a jury find someone not guilty? And it says, yes, they can. It's called an acquittal, judgment that a criminal defendant has not been proved guilty beyond a reasonable doubt. In other words, a verdict of not guilty.
Okay. I think we answered that question, huh?
Mm-hmm.
Okay. Go on.
So public defender, defense attorney. The attorney who represents the accused in court. Their job is to find the best possible verdict for their defendant. It is very important to be able to talk to your public defender and trust their legal advice. Pro se.
Yeah.
What was that?
I agree. I mean, I'm glad you have a public defender or an attorney.
Pro se. This means advocating on one's own behalf before a court rather than being represented by a lawyer. Defendants are automatically assigned a public defender if competency is raised, and the option to go pro se can be visited once competency has been restored.
Mhm. All right. So would you like to read through the pre-test and see how you do?
Oh, all right. Excuse me.
Or
Do I have an attorney? If so, what is his or her name? When was the last time we spoke? Yes, I do have an attorney. The attorney's name is Christopher Smallwood, and the last time we spoke was in court, which I believe was February 15th.
Oh, okay.
2, how should I prepare my attorney before going back to court? Honestly, I think just being honest.
Yes.
3, what are some examples of important information to share with my attorney? My side of the story, relevant facts, anybody who could be a character witness.
Right. And they're suggesting also criminal history, mental health history, learning and developmental disabilities, and details associated with the allegations and what they recall regarding the alleged crime. Different for everybody, though, you know.
Mm-hmm.
Okay, 4.
4, do I have any concern about my attorney's ability to help me? Yes, my attorney has even stated that to the judge he's not going to commit due diligence. I once brought up due diligence, and then my attorney asked, "What's due diligence?" And then the judge responded, "A licensed attorney asking what's due diligence? How do I not rule ineffective assistance of counsel?" So
Do you have an option to get another attorney, Kenneth?
I don't know. I've spoken that with the judge, but currently incompetent to proceed, so I have to go from there.
Oh, okay. Right, number 5.
Can my attorney talk to other people about my case? Why or why not? I believe he can talk to witnesses, investigators, and the district attorney, depending on what information.
The answers, according to my book, is no, confidentiality, client-attorney privilege.
Oh, okay, then I guess it's no.
Yeah. Okay, 6.
What should I do if I disagree with something my attorney tells me? Well, I can discuss it with my attorney. I can seek other legal counsel.
Mm-hmm.
I can also bring it up to the judge, like I've done in the past.
Right. That's all you can do.
The matching game. What is a defense attorney? So should I basically say true or false to all those?
Yeah, let's do it that way.
Okay. True or false? Defense attorney takes you shopping. That's false. True or false? Defense attorney gives you contact information. That's true. True or false? Defense attorney defends you against the charges. That's true. True or false? Defense attorney evaluates the charges. That's true. True or false? Defense attorney gives you a birthday gift. That's false. True or false? Plays sports with you. That's false. Defense attorney prepares a defense. That's true. That's their whole point. Defense attorney listens to what you have to say. They're supposed to. But I believe me going through these classes is kind of a thing that the defense attorney is really not listening to what I have to say. True or false, defense attorney advises you what to say. That's true. The defense attorney does advise you what to say. True or false, defense attorney advocate who speaks for you. On occasion they do, but sometimes they don't, such as ineffective assistance of counsel. True or false, defense attorney stays involved. That's true. True or false, defense attorney investigates and assesses. They're supposed to. They can hire an investigator and get information and make reports and go from there. True or false, the defense attorney explains to you about court and is educated and informed. They're supposed to. So I guess that would be true. True or false, defense attorney reviews the evidence with you. That's supposed to be true. True or false, appears in court for all hearings. That's true. True or false, defense attorney assists you in getting housing. I don't know. I hear sometimes they are, sometimes they aren't, but I think I'll just say no to that.
Okay.
All right, and that's all of them.
Okay, so the next one on page 20 of your book, I believe, if we have, they're asking you what kind of questions you might want to prepare to ask your attorney.
Have you committed due diligence?
Right. That's one of your biggest concerns, isn't it?
Yes, that is correct.
Okay. Is that your only question to him?
Basically, yeah, right now.
That's fine. There's nothing wrong with that. Now then we just have the assessment with the same questions. Do you want to review them or are you good?
I'll go through a review real quick. Do I have an attorney? What's up?
Let's do it.
Do I have an attorney? If so, what is his or her name? When was the last time we spoke? Yes, I do have an attorney. His name is Christopher Smallwood, and the last time we spoke was in court, which I believe was 2023, February 15th, Thursday. 2, how should I prepare my attorney before going back to court? Really don't know. I talk with him, but I only talk with him like at court. Most of the time he blows me off or he's too busy with other cases. So, however I can. Number 3.
I would hope.
What's up?
I would hope that the attorney would give their client an opportunity to have a meeting before you walked in the courtroom. Maybe that's not the case, huh? With your attorney?
You have a public defender.
Okay. All right.
3, what are some examples of important information to share with my attorney? My side of the story. 4, do I have any concern about my attorney's ability to help me? Yes, I do. Based upon the fact that he asked what due diligence is, and then the judge stated, how do I not rule ineffective assistance of counsel?
Right.
5.
A little scary.
What's up?
It's a little scary.
Seems like a setup. 5.
Okay.
Can my attorney talk to other people about my case? No. Client privilege. Number 6. What should I do if I disagree with something my attorney tells me? I can discuss it with him, or I can bring it up with the judge, or I can seek other counsel.
Correct. All right. Any questions on module number 4?
Nope.
You're good? Okay, so module number 5 is, oh yes, understanding the court procedure proceedings. You want to read the introduction?
Alrighty, Module 5, Understanding Court Procedure and Proceedings. This module will introduce you to concepts and a general understanding of what happens in court and how the system works. We recommend reviewing the vocabulary from the understanding rules module as a refresher for this topic, as many of the same terms are being used.
Right.
Objectives of Module 5. Objectives of Module 5. This module focuses on introducing how a court system works, understanding basic procedural concepts, understanding the idea of burden of proof, and how it affects the proceedings.
Right.
Vocabulary.
Mm-hmm.
Charge. This is written on a piece of paper by the prosecutor and says what law you are accused of breaking. Defendant. When you are charged with a crime, you are then referred to as the defendant. Testify. To give evidence as a witness in a court of law, testimony, speak. Burden of proof. This means the prosecution has to prove you are guilty. You do not have to prove you are innocent. Officially, you are considered innocent until proven guilty.
Mm-hmm.
Would you like me
Okay,
to
then
go
we go to the assessment.
the pre-course test?
Yes.
Oh, excuse me. Ugh. Finish the sentence. When they say a man or woman is innocent until proven guilty, it means that they have the presumption of innocence until they are found guilty by a jury or a judge.
Yes, that's true.
You want me to go on to number 2?
Yes, please.
If you've been charged with a crime, it means the judge has proof you did something wrong. That's not necessarily true. That could be false.
You're right. Because
Number
if you've been charged with a crime, it means the district attorney wrote to the court stating what law you are accused of breaking. That's all that means.
All right.
Yep, you're right. You're right. Okay, and so then 3?
What is the person charged with a crime called? A person that is charged with a crime is normally called the defendant, also called the accused.
Yes, that's true. All right.
4, in court, it is A, the state against the defendant, B, you against the judge, C, you against the witness. It's normally A, but it can be all 3. So I'll officially say A, the state against the defendant.
And that agrees with the curriculum. Good job. Number 5?
5, the defense attorney and the prosecutor can both call witnesses in court. Yes, that is correct. Both sides can call witnesses.
Yes. And number 6?
6, it is the job of the district attorney or prosecutor to A, to present evidence that you are guilty, B, to present evidence that you are not guilty, C, to testify in court. It is the job of the district attorney to A, to present evidence that you are guilty.
All right. Let's see what's next.
7, to find you guilty of the crime you are accused of, the prosecutor has to prove you committed the crime but didn't mean to. That's kind of a gray area. To find you guilty of the crime you are accused of, the prosecutor has to prove you committed the crime. That's true. The other little part, but didn't mean to, I think that's irrelevant. Whether you mean to or not is basically the degree of the charge. If you meant to do it, it's first degree. If you didn't mean to do it, it's second degree.
Right. And the curriculum is saying that the answer to number 7 is false.
Okay, false.
Okay.
That's
Yep.
a little confusing.
8? It is, isn't it?
8, the defense attorney helps you by presenting evidence that you are not guilty of the crime with which you are accused. That is completely true.
Correct. All right. Let's see what we have.
All right, objective activity. The following statements include multiple items that you need to know about court proceedings. With your instructor or in a group setting, you will discuss each statement. 1. You are accused of doing something wrong, a violation of the law. 2. The district attorney filed charges with the court. 3. The charge is written on a piece of paper and says that what law you are accused of breaking. 4. You are called a defendant when you are charged. 5. If you plead not guilty, there will be a trial to determine if you are guilty or not. The procedure is set up as the state against you or the people against you. In a trial, the judge or jury, if you have a jury trial, decides if you really did commit a crime. 7. You have a defense lawyer to help you. He or she tries to prove you are not guilty, or if you are found guilty, that you should get a light or easy penalty or sentence. 8. The state will have a prosecuting lawyer, known as a district attorney, to argue against you. He or she will try to prove that you are guilty, that what you did was bad, and that you deserve a sentence or penalty. 9. The district attorney may ask witnesses to testify. The district attorney will ask questions of witnesses to try and get evidence that you did what you were charged with. The public defender defense attorney may ask those same witnesses questions to try to prove you did not do what you were charged with. 10. The defense attorney may ask witnesses to testify. The defense attorney will ask questions of the witness to try to get evidence that you did not do the crime with which you were charged. The prosecuting lawyer, district attorney, may ask questions of those same witnesses to try to prove that you did do the crime you are charged with. 11. In a trial to your guilt, the state, or how should I say, in a trial to prove your guilt, the state has the burden of proof. It is up to the prosecution to prove that you were guilty. You do not have to prove you are innocent. You only have to prove that the prosecution did not prove you are guilty. Officially, you are innocent until the prosecutor proves that you are guilty.
Yes. And they underscored that. I like that.
Yeah.
12?
12. When you are found incompetent to proceed, this means that even though you are not found guilty, you may have to attend competency restoration until you are competent. So are we going to go back up and talk about each one of those, or?
You'd like to? Or do you have a clear understanding?
To the best of my knowledge, I have a clear understanding.
That's what I thought too. But we'll have plenty of time to review them on other classes. So it's totally up to you.
We can keep moving on, I guess.
All right. So the course knowledge assessment. This is like the same questions, but
Yeah.
let's see. Yeah. Okay. Go ahead.
Oh, you want me to do them again?
If you would like to. Do you feel you need to, or?
We'll do them quickly, I guess. Finish the sentence. When they say a man or woman is innocent until proven guilty, it means that they are innocent until they are proven guilty beyond a reasonable doubt, which is either a verdict reached by a jury, or ruled by a judge. 2. If you have been charged with a crime, it means the judge has proof you did something wrong. That's false. 3. What is the person charged with a crime called? A person charged with a crime is called the defendant, also called the accused. 4. In court, it is A, the state against the defendant, B, you against the judge, C, you against the witness. The official answer is A, the state against the defendant. 5. The defense attorney and the prosecutor can both call witnesses in court. That is true. 6. It is the job of the district attorney or the prosecutor to A, present evidence that you are guilty, B, to present evidence that you are not guilty. C, to testify in court. It is A. It is the job of the district attorney to present evidence that you are guilty. 7, to find you guilty of the crime you are accused of, the prosecutor has to prove you committed the crime, but didn't mean to. False. 8, the defense attorney helps you by presenting evidence that you are not guilty of the crime with which you are accused. True.
Mhm. Very good.
Yeah.
And we completed module 5. All right. Module 6 is evidence. And this module introduces you to what is evidence, the types of evidence, and whom could be involved in presenting evidence. Objectives of module 6. The objectives are to learn the definition of evidence, including evidence and the various types of evidence, types of witnesses, direct versus circumstantial evidence. Okay, then we have a vocabulary.
Vocabulary.
So
Evidence.
you're okay with reading?
What's up?
Okay. You're still comfortable with reading?
Yes, ma'am.
No, you could do training videos. I swear, you should get a job for doing that.
Vocabulary.
Your voice is so good.
Thank you.
Okay, go ahead. Mm-hmm.
Evidence. Data presented to a court or a jury in proof of the facts in issue, and which may include the testimony of witnesses, records, documents, or objects. The defense and prosecution are each allowed to present evidence in support of their cases. The judge decides on the evidence allowed in court. Physical evidence. Tangible items usually found at the scene of a crime, such as important documents, photographs, weapons, fingerprints, blood samples, hair samples, DNA, etc. Witnesses. A person who may know something about what you did or didn't do. A witness will testify from the witness stand, answering questions asked by both lawyers. Witnesses can include victims, police officers, forensic experts, physicians, friends, and family. Witness statements. Spoken words that may or may not be factual. A confession is considered a witness statement, but sometimes confessions are actually coerced and then ultimately are null and void. Testimony. A formal or written statement, especially one given in a court of law. Hearsay testimony, secondhand testimony, a statement that is offered by a witness as the truth. However, the statement was actually made by someone other than the particular witness. Alibi. The defense by an accused person of having been elsewhere at the time an alleged offense was committed. Eyewitness. A person who actually sees some act, occurrence, or thing that can give a first-hand account of it. Alibi witness. A person upon whom a defendant relies in establishing an alibi. Character witness. A person who attests to another's moral conduct and good reputation in a court of law. Expert witness. A person whose opinion, by virtue of special knowledge, skills, certification, training, or experience, is accepted by the judge as an expert. In other words, a medical specialist. I think it's odd that they put medical specialist instead of medical expert.
Right? They're referring to expert, right?
Mm-hmm. Direct
Okay.
evidence. Direct evidence. Evidence in the form of testimony from a witness who actually saw, heard, or touched the subject of questioning without relying on inference or other evidence. Circumstantial evidence. Evidence which strongly suggests something but does not exactly prove it. It helps people draw inference about a person acting in a manner consistent or inconsistent with the alleged crime.
Right. Have you ever been taught or heard of the term of material evidence? Do you know what that is?
Material evidence. Isn't that in there? Like, I guess it's not in there. So what would be material evidence?
You know? Okay, it'd be like videos, DNA, footprints, fingerprints, stuff like that. Okay?
Wouldn't that be
Tangible.
physical evidence?
It could be. It's just one and the same.
Because the physical evidence is tangible items usually found at the scene of a crime, such as important documents, photographs, weapons, fingerprints, blood samples, hair samples, DNA.
Right. Exactly. Alrighty then. We're at the course pre-test. Would you like to read that?
Let me scroll back down. Course pretest. Evidence can be presented by the district attorney in support of his case, can be presented by the defense of the case. C, can be hearsay. D, A and B. The answer is D, A and B. It is presented by the district attorney or the defense attorney.
You're absolutely correct, Kenneth. One.
Number 2, a character witness is a witness who saw the crime or event firsthand. B is a witness upon whom a defendant relies in establishing an alibi. C is a witness, such as a medical specialist, who by virtue of special knowledge, skills, training, or experience is qualified to provide testimony. Or D is a witness who testifies as to the character, moral conduct, or good reputation of the defendant. It is D. A character witness is a witness who testifies as to the character, moral conduct, or good reputation of the defendant.
Correct.
3. A confession is considered A, witness statement, B, physical evidence, C, hearsay, or D, none of the above. It is A, witness statement.
Correct.
4. An example of physical evidence is A, tape recorded statement made at the police station, B, testimony given on the stand, C, DNA, D, direct evidence. I believe it would be C, DNA.
Correct.
5. A witness statement can be made by eyewitnesses, alibi witnesses, character witnesses, and or experts. B, can be made by a person who testifies under oath in a trial. C, can be a confession. D, all of the above. I believe that a witness statement can be D, all of the above.
And you are correct. Well done. Okay, let's see what we have next. The course knowledge assessment.
You want to do those over again?
It's up to you. Do you feel like you need to, or you answered all of them correctly?
Yeah, I believe we just did all those.
I just did. And that would be the end of module 6. I can't believe we're going to go through half the book.
Are you sure we're actually supposed to take an hour and a half and not just a half hour?
I'm sure. I'm sure. But I will double check. But as far as I know, it's been 2 hours a week or an hour and a half. Module number 7 is appreciate charges and possible penalties. This module will introduce your client to the exact name and classification of the pending charges. It will also address the classification of their charges, potential penalties, and the importance of the allegation. And could you read the objectives, please?
Objectives of Module 7. Objectives of this module is to understand what the pending charges are, understand and appreciate the classification and possible penalties associated with each charge, become familiar with the allegations, and begin to identify the strengths and weaknesses of the case. In other words, appreciation of the evidence, witnesses, the likelihood of outcomes, etc.
Right.
Vocabulary. Misdemeanor, a less serious crime punishable by jail time. Felony, a more serious crime punishable by prison time. Sentence. The sentence is the punishment for being found guilty. If you are found guilty, the judge sentences you. The punishment can be prison, jail, or probation. Police reports, discovery materials. Details of the allegations provided by the police. This often includes statements made by officers on the scene, witnesses, and detailed evidence.
Mm-hmm. Very good. And then we have the test.
Course pretest. What are your current charges? My current charge is a class 5 felony or class 6 felony menacing. What are the police saying you did? What are their version of the events? The police say that I knowingly and willfully, feloniously menaced Hani Kamal with a real or simulated weapon. 3,
Mm-hmm.
is my charges a misdemeanor or felony? My charge is a felony. How much time could come with each charge? I believe each charge carries a maximum of a year or a year and a half in prison with a parole of 1 year.
Mm-hmm.
What is the maximum possible sentence I am facing? I believe that is a year and a half with 1 year parole.
Okay. All right. Very good. So you must have a copy of your charges, right?
Yeah.
You don't?
Somewhere I do, but they've changed rapidly. So, yeah, my lawyer has been sitting on his ass, so to speak, because in the copy of the discovery that I have, the alleged victim is an assailant named Hani Kamal. And Hani Kamal used to wear an ISIS armband, which violates 2339, material aid and support to terrorism. So I don't understand how he could be an alleged victim. But I heard that the victim changed like a half a year later to a year later. So I really don't know who the alleged victim is. I just, to the best of my knowledge, I'm still facing a class 6 felony of what do you call that? Felony menacing.
Yeah. Okay, so what I have, what they get shared with me is a class 5 felony, and the charge is felony menacing real simulated weapon. That's what I have. Let's see what else I can tell you. Does that sound like what you have? Or
Yeah, I guess.
so you, yeah, okay. Let me check here. Alrighty. Other things. Yeah. I'm just looking, see if there's anything I can share with you. Besides what you already know. Okay. So, mm, the details, what I have, so that you know what they're saying about you, the police report or whatever. So a detective was working off duty in uniform at some place called the View House. When a disturbance was observed in the front door area, a party who was at the front appeared to have thrown some sort of liquid at the manager, and this party also appeared to have had his phone out and making a recording. The detective started walking towards the party to see what was going on. This party, who was later identified as you, then out of nowhere produced a knife and opened the blade and had at that time menacing by pointing the knife towards the detective. And the detective pulled the gun and gave you repeated commands to drop the knife. And apparently they are under the impression that you refuse. I'm not judging you, and I'm just telling you what I'm reading, okay? At some point, you did close the knife and put it back in your pocket, and you began to walk away backwards. And the detective then continued to give you commands to put the knife on the floor and continued to refuse all commands and kept recording and getting agitated. Then the detective then holstered his gun and pulled out his baton and attempted to grab the suspect, you, to take him into custody. Then they're saying you shoved the detective back, at which time the detective hit you 2 or 3 times with the baton in the left side mid-torso and left upper thigh area. And then you kept going backwards and eventually ran into the group of on-duty officers at the corner of 20th Street and Market for the crowd control after the bars let up. With the help of those on-duty officers, you were successfully taken into custody and later charged with the investigative hold for felony menacing. So at least you know what. I don't know if you were privileged to that information or not.
That story has changed numerous times. So if that's the current story, then that's the current story.
Yeah. Let's see if there's anything else I can share with you. But I just want you to know, in case they ask you what happened, that you know what they're saying about you, you know. I think that's about it. But if you say it's changing all the time, I mean, that's fine.
Well, I don't think that's fine. That sounds like a setup.
Oh, no, but I mean, I believe you, whatever you're telling me. Okay. So, but you were right. It was a felony 5 menacing. And hopefully, maybe you could call your lawyer and get a meeting to help with the defense. Wouldn't that would be nice, wouldn't it?
He's not doing much. The judge called me a blue-eyed nigger. My lawyer's blue-eyed. He called him a blue-eyed nigger. And on occasion, I called the lawyer a blue-eyed nigger because he's not doing nothing.
Oh, my goodness. Not a good relationship with your defense attorney, I see.
Not at all.
I'm sorry.
I asked him if he could motion for dismissal on charges based upon my qualified immunity of being a United States intelligence officer in the United States Marine Corps. He says he's not going to. And then when I reference he needs to do due diligence, he says he's not going to. When I brought it up to the judge basically called me a blue-eyed nigger, told me to go fuck myself.
I'm sorry. Wow. Well, you know, you did very well today as far as your knowledge and your understanding and your cooperativeness, and I appreciate it. And I think that's enough information for one day, don't you?
More than enough information. I'm only used to these going a half hour. Is there a supervisor you can contact?
I will.
Thank you.
But I've been doing this a couple of years, and it's always been 2 hours, but basically an hour and a half. But I will follow up on that. But you did so well, and I want to thank you. And it's been a pleasure working with you today. And I guess, can we schedule for the same time next week?
Yep. Wednesday at 4 p.m.
Yes, and you have a great week, and I'll see you soon, okay?
Ma'am, Will this be the same link every time?
No, I'll be sending you a new one. I'll send it to your phone and also send it to your email, okay?
All righty, thank you.
You're welcome. And if anything comes up, let me know.
Okay,
Thanks a lot, Kenneth. Have a good day.
You too, ma'am.
Bye-bye.
Peace. Hello, everybody. That was an hour and 20 minutes of a company restoration class. Just found out that they redid the statement because that's not the initial statement. So it's odd because who are they saying I felony menaced? Are they saying I felony menaced the pig who told people to stab me with a dirty syringe, spit on me, call me a blue-eyed nigger, and attack me? Which did fucking happen. But anyways, yeah. An hour and a half in, same workbook. I had to do these before for 16 weeks. And they were only a half hour long. It was not even a half. They were like 15 minutes, dude. Honestly, we went through one module per meeting, per class. It was done virtually. And the each module only took about 15 minutes, yo. Yeah. So that's why I'm like, boom, boom, boom. Let's just go through it. Come on, I'll speak. I'll speak. But anyways, how's everybody doing? It's 5:21. There is what? They did you dirty, Kenny. Yeah, they did. And they're still trying to. And that's what yo, dude, have the Marines get their kids, yo. I'm done with this shit, yo. If the judge needs to end up like Judge Brian Flynn, good. You know, same with the prosecutor. Same with whoever they're claiming is the victim, which is odd because, see, they're lying in this. They stated that I threw something on the manager when I was actually trying to cover assault with a tactical flashlight. So anyways, I guess this is it. How much battery life do I have? 82%. All right. It's 5:22. This is a phone that I had the screen redone on. I'm using my Obama phone SIM card. And this is my normal phone. And so this one has 90% battery life. And this one has 82%. No, this is why I need a fucking gun. Because if I would have had a gun, I would have shot that fucking pig for pulling a gun on me. I told him to put his gun away. He disobeyed me. Hey, remember, I think I still got the body camera footage, so I could do another one, upload a video of terrorist monkey pigeon nig. Remember that? Remember when I had that video, terrorist monkey pigeon nig, and it showed the body camera footage of the fucking pig? And then the one of the sow, female pig. Yeah, let's see if I can go find those and put them up maybe next week. I got a lot of shit to do. I'm writing this multi-page letter, and I'm going to send it to all the family victims of Uvalde because I reported Uvalde before it happened. So I'm writing this letter that basically states, hey, the state of Colorado is prosecuting me to show support for the Uvalde school shooter and to cover up their impotency at properly performing law enforcement and protecting American children. And that Judge Adam Espinoza claimed the death of American children as job security. So, yeah. And, but anyways, yeah, at 6 o'clock, there's a rally for the International Women's Day, and that's at the state capitol. You want to see the body camera footage again? Yeah, I'll do what I can to put it back up and go from there. Yeah, here, if you want, I will drop the link. If anybody wants to, You can elaborate more on the armband guy. Oh yeah, at the View House they used to wear ISIS armbands, which is a violation of 2339. Um, yeah, View House business and employees have flown the ISIS flag and worn ISIS armbands. This is a violation of 2339, material aid and support to terrorism. How are they allowed to conduct business in America? Right? Oh, man. So I want to go to this women's rally, but I think there's going to be a couple of people there who hate me for my eye color. Such as that's crazy that they wore those armbands and flew that fucking flag, dude. Yeah. And then after I gave a lawful order to the pig to arrest the person to assault me, the pig committed belligerent combatancy, did not obey me, terrorist monkey pigeon egg, dude, Umar A. Shabazz. Yeah. I believe he was dishonorably discharged. So, anyways, yeah. Go to this women's rally march, and who knows what will happen, because I believe that some of the people who hate me for my eye color will be there. They'll try to stab me with a dirty syringe. Carol Funk does that all the time. She fucking hates me, but says she's my friend. I don't like being around her, and I don't want her around me. And she's working for some dude that some other dude said is running on an anti-Marine Corps platform. He was running for mayor. So I got that in that little note, or not note. It's going to be a multi-page letter. It's probably going to take 2 stamps. Let's type that in. How many pages can I send with one? How many pages can you mail with 1 stamp? Bam. Here's how to figure out. You can mail 5 sheets with 1 stamp. Oh, wow. Well, that one says 6. Less than that with 1 stamp. No, there's several different fucking things. I will take it to the fucking post office. Carol threatens you with dirty needles. No, the bitch has stabbed me with a dirty needle, dude. Her and a couple of others, yo. Yeah, I got a whole letter of that I'm putting out there. She's not just cunning, she's a fucking cunt. Or she's an ankle, 3 feet lower than a cunt. Yeah, we do not get along. She blames me for all the problems of the world. She'll blame me for gas prices, which is fucking disgusting. I think she once blamed me for the price of eggs going up. Yeah, she's just a hateful, fucking spiteful bitch. Yeah, so, anyways, anybody got something to talk about? I mean, it's 5:28 p.m. I've eaten already. What? Do you think she's working with old man? Oh, yeah, fuck yeah, she is, dude. Oh, yeah, fucking Ogden, Kansas, too tall, Rob? Dude, I wrote a letter to the judge requesting I get a PR bond and release from my bond because Brian Loma bonded me out, and Brian Loma was talking shit to me that Carol Funk and old man Too Tall Rob from Ogden, Kansas were threatening his life and talking shit about him because he bonded me out. And Ogden, Kansas, fucking Wish.com Too Tall. Wish.com Too Tall fucking kept talking about people needed to beat me in the head with a shovel and bury me with that shovel because I claimed to be a Marine. And, I wrote that to the judge, and then Wish.com Too Tall from Ogden, Kansas, he just made all those videos private. And then Carol started talking shit about that some more. Yeah. So, I got to finish this letter, and I will hopefully have it done. Let's see, today's the 8th. I bought personalized address labels that have my name and my address on them off of Amazon because I'll be sending at least 30 letters, maybe 40. So, yeah, that's how it is, yo. He stalks boys around in his minivan trying to lure them with apple fritters, I heard. Well, I remember back in the day when I was live streaming what was that, 3 fucking years ago? Easily in 2020. You guys, all people who basically, for lack of a better term, trolled me, said that you all found me because Wish.com, Too Tall, was constantly talking about me and joining up on my live streams. And some of you stated that you found him in a unsavory chat room looking for underage people. All right, I don't know if it was true, but I remember it could have been that YouTube kid who was telling me that, or whoever, or it could have been Dimrack or whoever. I don't even fucking remember, because the Amazing Awesomenicity channel got taken down. So, like, what the fuck does anybody do when all their video evidence is taken down? But anyways, yeah, we're an hour and a half into the stream. Those things are only supposed to last 15 minutes. As you can see, they lasted an hour and 20 minutes easily. So I think I'm going to call it, Put this away, unplug all that. The mushroom grow is going good. The mycelium is still spreading until it becomes spore media or something like that. I bet Wish Too Tall took your channel. Oh, dude, he even told me, or I heard on one of his live streams, because I was just like listening and watching. He reported every video. Like, he took a couple days off, or a couple of days, and he reported every one of my videos for violence, hate speech, nudity, profanity, and fucking everything, But he wasn't the only one. I know he wasn't the only one, because other people came up and said that they were doing that also. And yeah, that was some fucking bullshit, dude. So anyways, yep. So there we go. If there's anything you all want to talk about real quick, I got to go plug this in the turbocharger. So it's at 100%. And then I'm going to walk down there. I'm not going to ride my bike because I don't know if they're going to march, and I don't want to lock my bike up at the Capitol, because then the pigs will just let it get fucking stolen, or who knows. Or the people who hate me for my eye color or my service to the Constitution or being a Christian will pull some dirty shit. So, yeah. Here we are. And I think I'm just going to call it, unless anybody has something very relevant to state that they would like to discuss. I guess I can turn this off. Put that over there. And go from there. So, yeah. Everybody in YouTube land, stay warm if you need to stay warm. Stay cool if you need to stay cool. Stay healthy. Stay safe. Stay sober if you're choosing sobriety, because right now I'm choosing sobriety. I've had marijuana since the beginning of the year. But I'm in the middle of some stuff, buddy, but you should go live at the rally. Oh, I will. Yeah, I'll head off in about 15 minutes, walk down there. That should be about 15 minutes. So, yeah, everybody in the YouTube land, do your thing. Stay warm if you stay warm. Stay cool if you need to stay cool. Stay healthy. Stay safe. Stay sober if you choose sobriety, because I'm choosing some sobriety. Peace. Love you. And broadcast click. And broadcast click.